But it has to be that the property owner has to know that you're asserting status as a dwelling, right? As opposed to status as a guest. Doesn't that have to be the fact? I mean, because you can't simply go into somebody's home and say, this is now my dwelling, and now I'm a tenant.
Certainly. Right? There would be both objective and subjective indicia of whether this was actually somebody's dwelling place. Whether they intended to live there would be the subjective part.
Would a contract be an objective criteria, not necessarily conclusive, but an objective criteria that we could turn to say, have the parties agreed to status?
It may be one indicator, but in this case, the contract term defining the parties as innkeeper and guest was unenforceable.
What if the contract said this may not be a dwelling place?
If the contract said that, but the parties acted otherwise, then that would be an attempt to define the legal status of the parties,
Why?
which this court.
Why wouldn't that just be a breach of the contract by the person attempting to use it as a dwelling place?
There may be some line drawing that has to happen.
Well, that's what we do. So
Right.
I'm trying to figure out where it should be.
Let me try it a different
course.
way. A contract has to mean something. Assuming it's not unconscionable, assuming it doesn't violate public policy, it has to mean something. And it is supposed to be the memorialization of two parties' agreements. So if and when that happens, the subjective intent of someone who's, in this case, living in a space or staying in a space cannot unilaterally overrule the express written agreement between the two parties. Do we agree on that?
We do agree on that, Your Honor, and that's not what we're calling for here.
So what the move you're making is you're saying, notwithstanding the written agreement that says that you're a guest, that this person's subjective intent was to treat it as a dwelling. And then I think maybe what you're saying is that the tacit behavior of the person who calls himself an innkeeper is allowing the written words and agreement to transform into something that's not what the written agreement says. Is that the thrust of your argument?
That's part of what happened here, Your Honor, but it's not just that our clients had a subjective intention to live there. It's that Efficiency Lodge offered them a place to live.
So
This
is what I think all of these questions are getting at is, you say that there's no question that they used these rooms as their dwelling places. To create the landlord-tenant relationship, the owner has to grant the right to do that, right? So actual possession is some evidence of that, but you also need something else, and I think we're trying to get at what is the something else? Do you need a written agreement that says it explicitly? Do you need sort of conduct that shows consent or permission? Do you have cases that help us figure out what that answer is? What's kind of your view on how can you show a grant, and how does this agreement affect that analysis?
You can look simply to the intent of the parties. That is one way to get to what the...
That's best reflected by the contract, right?
It's not just reflected by the contract in this case.
Best reflected by the contract. How is a landlord to know that the subjective intent of the guest is contra to the language of the contract?
Your Honor, I can't...
But to look to their actions, moving in appliances, I mean, right. And where's the legal authority for that? So that the landlord is on notice that that relationship has changed in the eyes of the guest.
But in this case, Your Honor, the landlord knew. They knew that they were living there, and they had invited our clients to live there as their home.
Is that in the record?
It is, Your Honor.
Where in the record do we show sort of knowledge or tacit agreement from the landowner that they were living there and could live there or use it as a dwelling place?
It's apparent from the homepage of their website where it says stay a night or stay forever.
Well, I mean, look, there are all kinds of other contract scenarios where we'd say that that's puffery or, it's a slogan. The terms of the agreement don't seem to say that in the same legal terms.
With all due respect, Your Honor, it's not just puffery in this case, though. It was an invitation to anyone that they could live there as their residence.
If I don't find that a compelling factual point, what else do you have?
So, Your Honor, I want to go back to this question that was being asked about whether innkeeper and guest could be defined by the parties in the contract and whether that's going to govern things. In this case, it cannot. That is because whether there's an innkeeper-guest relationship is a conclusion for the courts. That is not a conclusion. That is not a legal or a factual conclusion that can be reached in a contract. That's a legal conclusion.
So I agree you can't have a contract that says hey, here's all the details about what we're agreeing to, and then clause B, this creates an innkeeper-guest relationship. Because that does violate, I think, 44.7.2, which says you can't waive all this other stuff. But if what's in that first part actually does describe what the law would understand as an innkeeper-guest relationship, then then that has effect, right? So why does the agreement here, without looking at the website, why does the agreement here, or actual evidence that's in the record of the parties' sort of external sort of parole evidence of their agreement, how does that show that there's landlord-tenant here?
So there's a couple of examples of that, Your Honor. First is from the plain language of the statute of what an inn is. It is a tavern, hotel, or house of public entertainment for guests. It does not define or describe the relationship that the parties had here.
Well, but does that answer whether this is a landlord-tenant relationship?
It does, Your Honor, because
So if
but
it's
you're
not
speaking
for
of-
entertainment, then necessarily is landlord-tenant?
no, but if there's an occupancy of a space, typically it's going to be one or the other. It's going to be short-term occupancy with the rights, at least in a business relationship, with the rights of an inn and a guest on one side, and that's the innkeeper statute. That covers short-term relationships between lodgers and inns. Typically, we're referring to them as hotels.
Can
And-
one set of rooms have both, can an owner-operator be both an innkeeper and a landlord in a multi-unit complex?
I think they could, Your Honor.
What is required
How
to,
can you structure your business under that theory?
I'm not saying it's a good idea. I think it would be confusing and complicated, but certainly there could
So,
be.
But what about if there are people, I mean, look, I'm going to accept as true for just a second, the idea that for these three people, this was their dwelling, everybody knew it, everybody agreed to it, notwithstanding the written agreement. What about all the other people who just came for a few nights? Does that mean that the owner-operator is then treating those people as guests and everybody else as a tenant?
It could very well be the case that not all of those people who live in the same building would be considered tenants. Absolutely.
Counselor, is it your contention that they started as landlord-tenant or that they started as guest innkeeper? And if they started as guest innkeeper, what's the demarcation point?
In this case, our clients started as landlord-tenant. They took Efficiency Lodge up on the offer to use it as their dwelling place. They moved their furniture in. Ms. Preston paid a security deposit, which, by the way, is governed by the landlord-tenant statute and is contained in the contract that she signed with Efficiency. They cleaned their own rooms. Ms. Preston provided her own linens. And those two things are very important because those are specifically required of inns in the innkeeper statute.
Counsel, so those are facts that tend to show that they, in fact, used the rooms as a dwelling place. What is your best evidence in the agreement or otherwise that the owner granted the right to use it as a dwelling place? In other words, the sort of consent portion of it.
Aside from the advertisement,
Yes.
Which was an invitation to live there,
Which you don't
Miss-
contend could change the contract.
the contract, no, I think it could change the contract. I think it could change the
Is there
contract,
an
Your Honor.
affidavit where the owner-operator says that he or she knew that the units had been converted?
No. But it is undisputed in this case that they were living there in their
Undisputed because
dwelling
it's been
place.
stipulated to, or just because no one's challenged it?
Both, Your Honor.
well, undisputed that they were living there, not undisputed that the owner knew that it was being used as a dwelling place, right?
Our clients had lived there for years.
I-
Mr. Neeson had lived there for 5 years at the time that this case was filed, and Ms. Preston had lived there for a year and a half, and it is not in the record that she refused to pay rent
But
that entire time.
We generally recognize the freedom to contract. And for the entirety of the duration, the landowner was in possession of a contract that said, I agree that I'm a guest.
That is true.
So the fact that they lived there for a long time, I mean, it cuts both. I'm trying to figure out what, you say they moved in as landlord tenants because when they moved in, they intended it to be their dwelling. But when they moved in, they signed a contract, as onerous and maybe distasteful as it may be, that said, I'm not a tenant, I'm a guest.
But the legislature has made this decision already. They have decided that landlords and tenants cannot waive their right to the eviction process
If they're
in
a
contract.
landlord and a tenant.
That's true, but that is a legal conclusion, and that's not a conclusion that could be defined in the contract. And this court found in Wolken v. National Acceptance, which is at 22 Georgia 487, that mere nomenclature of the contract is not determinative as to the parties' legal
You
relationship.
can't just call them an innkeeper and a guest and have it necessarily then be an innkeeper and a guest and evade landlord-tenant protections. But you do have to look at what's in the contract to see what it is that the owner is actually granting. Because if the property is used in a way that the owner has not granted it for,
In answer to Justice Penson's question, the landlord's intention, is the open-ended date of termination part of that? That the landlord allowed that to be open? Does that indicate that perhaps this had turned into landlord-tenant versus innkeeper?
That's one indication, as is the fact that they set aside, that they required our clients to pay the cost of an eviction if an eviction were filed.
but
It's
is it
also-
really
facts.
open-ended date of termination if the contract says re-rent? I mean, doesn't that necessarily mean that the date of termination is every week? And then you can re-rent as long as everybody agrees?
It was, in effect, Your Honor, an at-will tenancy. That's what it was,
I mean-
because
Yeah, I mean, the problem is that a lot of things didn't go right. You know, you have a written agreement, and then you have a lot of behavior, and a lot of things didn't go right. And so in a perfect world, you know, it sure seems like, according to the written contract, it would terminate every 7 days, but with a right of renewal. That doesn't seem to be what happened here. And the question that I think governs over all of the various facts that the trial court and the Court of Appeals look to and fit on either side of the innkeeper or the tenant equation is there has to be, for a landlord-tenant relationship, a predicate grant of the kind of authority and possession that would allow that kind of relationship. And absent that, I'm not sure how the facts that you've been pointing to matters if the grant isn't there.
because the grant was inherent in the relationship that they had, not just from the very beginning, but over the weeks and months and years that our clients openly lived there as tenants, that they received mail there, that their children were enrolled at school using that address and picked up right out front openly in front of Efficiency Lodge.
Counsel, can I ask you briefly about the status of the plaintiffs at this point and your views on whether that moots this appeal?
It does not, Your Honor. Mr. Barnes was correct that Ms. Preston is gone. There was a dispossessory filed against her, and she left voluntarily as part of an agreement in that case. But her claims against Efficiency Lodge for damages remain. Mr. Neeson's does still live in the property, although a dispossessory action is pending in front of the DeKalb Magistrate Court. And Ms. Weaver was gone before we even filed the case and has damages. So all three parties have damage claims that would depend on whether they were tenants or guests at an inn. I think it's important to sort of remember statutory interpretation rules in that the legislature, it is assumed that they would not create statutes that are in conflict with one another. So the landlord-tenant statute specifically says that that landlords cannot waive the duty to go through the eviction process. If we were to allow Efficiency Lodge or any other landlord to define themselves in a contract in a way that does that very thing, waives that right, it would be in conflict with the landlord-tenant statute.
Thank you, counsel. Mr. Barnes, you have about a minute and a half.
I want to address the issues that both of you have raised, Justice Warren and Justice Penson. You have to have a grant of possession, and that possession has to be exclusive. In this contract, it was never exclusive. They had the right to enter the premises, to do pest control, to do maintenance. They kept a key. There was never a grant of exclusive possession.
Is that true of a normal apartment lease too, though?
Not generally. Generally, an apartment lease, and I've drawn both of them, generally an apartment lease says that you can notify the the tenant, and then the tenant may allow you to come in. In other words, it's a joint agreement. You can keep them from coming out, from coming in, but you cannot in an innkeeper's agreement. Let me say this, the second thing. what you have to do, if you adopt my distinguished counsel's argument, is every case is going to be an intent case. Well, you saw him picking up the kid, so you must have known. And therefore, you abrogated the contract or you amended the contract. I don't know what the new consideration is there for that, but still that you would have to do it. These folks, in the open marketplace that exists, just tell them how long they have to live there before they leave, before you have to make them leave. I think that's the General Assembly's job.
Thank you, counsel. Thanks to both of you for the fine arguments and the good briefing. We will have you a decision as soon as possible. This court will now stand in recess for 10 minutes.
All rise.
All rise. You may be seated.
Madam Clerk, if you'll please call the next case.
Yes, Your Honor, S23A0421, State of Georgia versus SisterSong Women of Color Reproductive Justice Collective et al. Stephen Petrani for appellant, Julia Stone for appellant.
Mr. Petrani, you may proceed when ready.
Thank you, Your Honor. May it please the court, I'd like to reserve 5 minutes of my time for rebuttal to the extent that I can.
Keep your time, and I'll try to help you.
Yeah. The Life Act engenders strong policy views, but there is nothing controversial or difficult about the legal question before this court, which is simply whether an erroneous, overruled judicial opinion can invalidate a state statute. It plainly can't, as centuries of unbroken legal understanding make clear. Under Dobbs, the actual controlling decision in this case, the Life Act is plainly valid. And because the federal Constitution has not been amended since 2019, it was valid when enacted too. As this court put it not so long ago in Olivic versus State, there are few principles in Georgia law more venerable than the fundamental principle that a constitutional provision means today what it meant at the time that it was enacted. That means that because the Life Act would be valid if enacted today under the exact same federal Constitution, it was valid when it was enacted. Now, the Superior Court's order to the contrary is not just gravely wrong. It would fatally undermine the separation of powers. It would transform courts from tribunals that resolve concrete cases by interpreting law into constitutional oracles, handing down constitutional amendments from on high. That is not the judiciary's role, and this court should make that emphatically clear. But even if you disagreed with anything that I just said, in this case, we're talking about a federal decision. And the U.S. Supreme Court has made clear beyond peradventure that its decisions must apply retroactively, that lower courts and state courts cannot simply decline to apply its decisions.
So, Counselor, let me ask you, what relevance then does Adams have? And it appears that your colleagues on the other side rely heavily on the quote, statutes of void from inception when contrary to the Constitution at the time. And so what says you regarding that particular provision, separate and apart from the holding of Adams, because I think I may agree with you, the holding was not based upon the void doctrine.
Yeah, so plaintiffs do rely essentially entirely on Adams, and the reason why is because they take one line out of context and misconstrue it, and I'll explain that in a little more detail.
Please.
But the key point here is that what this court has said numerous times, and we're not challenging this point in this case, is that if a law is in fact unconstitutional when enacted, then sure, it's void for all time. That's fine. Our point is that this law was not, in fact, void, unconstitutional, anything when it was enacted. Now, I want to just discuss Adams briefly. There are many reasons plaintiffs have this case wrong, but I'll focus on three. The first is, let's just assume that Adams says more or less what plaintiffs say that it says, which is the court was saying, you look to court interpretations at the time, and because there were no court interpretations at the time, we're not going to apply the void ab initio doctrine. At best, even under their reading of the case, that is dicta that says nothing about overruled judicial decisions. I mean, it just doesn't say anything about that.
In your view, is another way to say what you're saying, that view of Adams, even if you accept your opposing counsel's view, ignores the effect of retroactivity?
Yeah, it just doesn't address it because there was no reason to, right? There were no judicial opinions to even look at in that particular case. But the second point I would say is they just have Adams wrong. This court itself explains what Adams did. In Lawrence versus Lawrence and James Beam, the court specifically said all that Adams was about was this sort of exception to to the void ab initio doctrine for, unjust results or something like that. And James Beam specifically said that Adams was just about declining to apply a decision retroactively, not prospectively. So that's
And this
number
court
two.
was overruled.
Yes,
by the
and this,
US
well, and this
Supreme
is the third point. Let's say that, ignore all that. James Beam said it's doing the same thing that Adams did, and the court was overruled by the United States Supreme Court, which said when it comes to federal decisions, you can do what you want with state decisions. If you don't want to apply those retroactively, that's not our business. But with federal decisions, you must.
Hasn't this court since that time applied our own substantive decisions retroactively?
Oh, yeah, so, yes, absolutely, Your Honor. In the vast majority of cases, this court will apply its own decisions retroactively as well.
And has done so recently.
Oh, yes, absolutely. And the only time it doesn't, and the court has been very clear about this, it's when particular parties can show that they have some sort of particular interest or reliance on some previous decision, then with respect to that particular party, the sort of equitable discretionary exception to not apply controlling law, might kick in.
I accept that this court has done that. That is an accurate description of what this court has done. Is that jurisprudentially sound?
Yeah, so I think, so first of all, it doesn't make any difference in this case, because in this case, we're arguing you should be applying a federal decision retroactively, not that you should come up with some sort of exception to it.
So you've made this point a couple of times, and I want to make sure that I understand the state's argument here clearly. This notion that you apply the federal rule retroactively is independent from our state constitution's direction that which violates the state or federal constitution, regardless of the federal interpretation that may come later, that's in our state constitution. So that's a state rule. This whole doctrine is not predicated on what the federal rule about retroactivity is. It's only in our constitution, right?
If you're referring to the rule that unconstitutional statutes are, statutes in violation of the U.S. Constitution or the state constitution are void, yes, that's in the Georgia state constitution, yes.
Okay. So I understand that retroactivity is the general norm of the rule. I'm not sure that the federal court's explanation that they want their things to be done retroactively control an interpretation of Georgia's constitution. It may reach the same ultimate conclusion, but I'm not sure I buy the state's argument that this federal mandate can dictate how Georgia's constitution is interpreted.
So, Your Honor, it's not dictating how Georgia's constitution is interpreted. What it's dictating is what was or was not valid under the federal constitution in 2019. Plaintiff's entire theory, such as it is, and there are many, many problems with it, but their entire theory is based on the idea that federal law made the Life Act void in 2019. If it weren't federal law, it's not even clear what they're referring to. They're talking about the Roe-Casey interpretation of the federal constitution.
So federal retroactivity rules is how you measure Roe and Casey because Dobbs
Yes.
decided and applies retroactively.
Yes.
It's not necessarily a Georgia constitutional method of interpretation, though there are other arguments to be made there. All you're saying is once Dobbs is passed, because of the retroactive application, Roe and Casey are void. They're not even, they were wrong.
Void is actually a good way of describing them.
What is the difference between void and void ab initio? Is there a difference?
No, so void just means that something, has no legal effect. Void ab initio just means it has no effect from when it started. In fact, the void ab initio principle, as we try to lay out in our briefs, very much supports our position. The idea of the void ab initio principle is that law is fixed. So if a court say in 2000, we'll just pick that number. If a court says in 2000, this statute passed in 1980 is unconstitutional, well then it's always been unconstitutional, assuming there wasn't some amendment to the Constitution, because courts don't make the law up. They just tell you what the law is in their estimation.
Is that?
Counsel, let me ask you a hypothetical question, not the facts of this case,
Yes.
to be clear. All right. Let's say Dobbs was not, let's say they dismissed as improvidently granted. The Supreme Court did not enter in any opinion whatsoever.
Yes.
But at the same time, through the constitutional procedure, the federal Constitution was amended to provide and protect, some sort of restriction on abortion access or whatever. And so then Roe and Casey are still on the books. They are still, the valid interpretation of the 14th and other
Yes.
provisions. In that world, would the 19 Act of the legislature, and assume that happened the same time as Dobbs,
Yes.
would that act by the legislature be void?
So I want to answer that carefully because we have a third argument that even under Roe and Casey, it wouldn't be void, but assume that it would be.
Ignore that
Considered
argument.
But assume that it would be. Assume that it would be.
Should it be considered under Roe and Casey?
Yes,
Okay,
yes.
got it.
In that case, yes, you would look at, and the reason why is not because this court would be saying, oh, that, I agree with Roe and Casey or something like that. It would simply be because those decisions still bind this court as to the interpretation of the previous Constitution. So yes, that is our whole point. If the federal Constitution had been amended, then there would be a very different analysis as to what it looks like at the time of enactment versus now. But the point is that the Constitution has not been amended. And I think that if you take this view that judicial opinions are effectively the Constitution themselves, that goes down a very dangerous road. And
Now, your opposing counsel does not say that expressly, correct?
I mean, it's not clear. Actually, I think if you read the
I'll
brief,
ask-
they
I'll
say,
ask them.
I mean, you can ask them, but if you read their brief on, say, for instance, page 2, they say that the Life Act violated the supreme law of the land. The Superior Court in the decision below called Roe the supreme law of the land. I mean, it referred to these judicial opinions as the supreme law of the land. That's the Constitution, as this court, going all the way back to Beale versus Beale, has been clear on, as the United States Supreme Court has been clear on. I mean, just to give one.
And to be fair, that could be interpreted in the way you're saying, which would be erroneous. It also could be interpreted to say that until otherwise notified, that is what is binding as to federal constitutional law decisions in that space.
Well, it's certainly binding on courts. And the Georgia Constitution actually makes this very clear. Article 6, Section 6, Paragraph 6, a kind of unfortunately numbered provision, but it says this court, the Supreme Court of Georgia's decisions, are binding on other courts. It does not say binding on citizens, the legislature, the executive, and so forth. And that's because judicial opinions are very important, but they are not themselves the Constitution. They're interpretations of the Constitution necessary to the judgments that this court makes, and they will bind courts in the future. And so they have they're extremely important pragmatically in the sense that, we don't deny, for almost 50 years, federal courts were enjoining state statutes on the basis of Roe and Casey. They clearly had strong import as a practical matter. But when the Supreme Court overrules that in Dobbs, what it is saying, and what it said, by the way, it was explicit about this, is that Roe and Casey were always wrong, and those decisions were always wrong. And so the federal Constitution has to be understood from 1900, 1950, 2000, 2019 to today.
Is that one reason why you said in your brief that there's a difference between the change in judicial doctrine versus the change in the law?
Yes, absolutely, Your Honor. Judicial doctrine, case law, is very important, but it's not the same thing as the Constitution itself or a statute itself. When this court changes an interpretation of the Constitution, it has never suggested that it's changing the Constitution. And for everyone from Blackstone up through, justices on this court and the Supreme Court today have recognized that when a decision is overruled, it's not a declaration from this court or the United States Supreme Court that the underlying Constitution has changed. It is a declaration that the court was wrong, and it's correcting that mistake. I mean, judicial decisions, by definition, look backwards. They look at what already happened. Justice Scalia has very good concurrences on this in Harper and Hyde, where he explains the classical and generally undisputed view that judicial decisions tell you what the law is, as the judiciary understands it, but they don't create the law. And in fact, if you're going to go with this, the theory of the Superior Court's order and plaintiff's theory, you're really stuck with the idea that judges are essentially just creating the law. And I think this is very apparent in the Superior Court's order, especially in footnote 5, where the Superior Court says, there's nothing that makes Dobbs correct and Roe incorrect or vice versa other than sort of will to power, as it were. Like one side has more justices in one decision and one side has more justices in another decision. But I don't think this court has ever adopted, and certainly the United States Supreme Court has never adopted, this kind of legal nihilism where there's no real content, the Constitution doesn't mean anything until a court says it. I mean, and that really can't be it. Otherwise, when a novel question comes before this court, what is this court doing? I mean, it has to look at the Constitution and figure out what it thinks. But the
Your
key,
bottom line is, even if people view it that way, that it's a change in composition of the court, the holding of the Supreme Court of the land is the holding of the Supreme Court of the land.
Yes. So, and I want to be clear, every single member of this court could disagree with Dobbs. I mean, that is not, there's nothing about this decision that says you have to agree with Dobbs to enforce it. The point is simply that it is in fact the controlling decision, and because it's the controlling decision, it's the controlling interpretation of the federal Constitution going back to essentially, I guess, 1868, when the 14th Amendment was passed. And so that's the point that matters to this case. A lot of what the plaintiffs talk about in their brief, we don't even really disagree with. We don't disagree that you can look at 2019 to determine the validity of the statute, but the point is, if you look at 2019, you'll find that the statute was valid. I'll try to reserve the rest of my time for rebuttal.
Thank you, Mr. Petrani. Ms. Stone?
Morning. Thank you, Mr. Chief Justice, and may it please the court. My name is Julia Stone. I have the privilege of representing the appellees in this case. Your Honors, I'd like to start with 4 brief points, and a lot of which we didn't hear a lot about. First goes to Justice Bethel's comments that the void ab initio clause is a product of the Georgia Constitution. And at its core, it is a restriction on legislative overreach. And the void ab initio clause requires that a voidness analysis be performed as of the moment of a statute's enactment.
I'm sorry, I just have to ask a question about that. That may be true in a lot of instances. I mean, I think there are just a lot of examples where that would be true, where the Constitution or another statute very clearly says something, you can't do this. And then another statute is passed and says, you must do this. I can see how you would say then, well, at the moment of the enactment, you evaluate whether that second statute is void. But that argument seems to exist in a vacuum and does not account for retroactivity for the application of judicial decisions. So can you reconcile that for me?
Sure. And one thing on retroactivity that I do want, we made this point in the briefs, but I want to make sure that I make it clear. The state never raised federal retroactivity below.
Well, we can still ask the question.
Absolutely. I just wanted to note that. The difference is, and again, this goes to Justice Bethel's question earlier, voidness and void ab initio is a question of the Georgia Constitution and the time-based inquiry that this court has read into the void ab initio clause for over 125 years. Retroactivity is a question of when there is a change of the law or a new judicial doctrine pronounced, whether that case law has retroactive effect. And this ties.
So retroactivity would apply to the piece of this analysis as between Dobbs and Roe and Casey.
It wouldn't apply to this analysis. It applies to federal claims. And there's no.
Is Roe a federal case?
Roe is absolutely a federal case.
So why would Dobbs, being applied retroactively, not have an effect on whether Roe is still good law?
Dobbs has a retroactive effect when the claim at issue in a lawsuit is a federal claim. It's what we saw in the federal lawsuit that many of the same plaintiffs brought.
So let me ask this. Your theory is that the Life Act violated the Georgia Constitution because at the time the Life Act was passed, it violated the federal Constitution as it was then understood.
Correct.
In your brief, you cite Sherman versus Atlanta Independent School District. And you cite it and you quote it as, it is clear that under the law when we decided Woodham in February 2008, the government action would have been ruled unconstitutional. But what happened in Sherman? How was the ultimate disposition of Sherman?
Sherman found that the law was not void ab initio.
It was not void ab initio, and why?
because there had been a constitutional amendment that was explicitly made retroactive.
Like a judicial opinion that said our previous opinions were wrong and were never the law. Distinguish the constitutional amendment in Sherman from Dobbs.
Sure. So again, federal retroactivity, we're looking at the federal claim. And the Georgia constitutional
We're not
amendment.
just looking at the federal claim, we're looking at the federal case law. I mean, this
Right.
seems like an awfully artificial, it's like you're trying to avail yourself of the Georgia constitutional, I'm sorry.
Can you distinguish Dobbs and the constitutional amendment in Sherman?
Sure. So the difference is that, as this court noted in Sherman, the Constitution, when it speaks, it can say whatever it wants, essentially. So when the people passed the amendment in Sherman that was made explicitly retroactive, that in some sense trumped the void ab initio clause of the Georgia Constitution, that because it was more specific and it applied so that the law was not void ab initio. Dobbs does not have any effect on the void ab initio clause.
No. But Dobbs expressly says the prior precedent was wrong, and I mean, whether anybody agrees with that, it says that, and it's the last word on that. In the same way that the constitutional amendment that the people adopted in Sherman said the prior understanding of, I mean, it's even sort of more remote, right? Because it says we changed the Constitution, and by the way, we go back and catch stuff that happened before the effective date. That seems to me to be a further reach. I understand the fact that it is a constitutional amendment, but that seems to be a further reach than an interpretive decision from a court that says we made a mistake.
Well, one of the really important things to keep in mind is, again, that the void ab initio clause is a restriction on the legislature's power. And the legislature—
Can you explain that too? Because I'm not following.
Absolutely. So it comes from a few things.
I mean, I don't view our judicial review clause as the void ab initio clause. That's our judicial review clause. It does speak about voidness, and it says laws that are unconstitutional or violate the U.S. or Georgia constitutions are void and so shall be declared.
Well, it's been repeatedly interpreted by this court as, and I haven't seen the phrase, the void ab initio clause, certainly that's a phrase I'm using here to—
We have referenced that clause in concluding that statutes or other actions are void.
Correct, Your Honor. And it was adopted against the backdrop of Beale versus Beale, which came in 1850. So a predecessor of this clause first appeared in our Constitution in 1861. And Beale noted that the legislative power was the power, quote, most apt to overleap its bound, and that when the legislature did overreach, those bounds shall be adjudged and rendered vain and fruitless, and their acts shall be considered void as a, quote, noble guard against legislative despotism. And since the incorporation of the void ab initio clause into the Constitution, this court, for example, in Jones, referenced the fact that when the legislature passes a law that is in violation of the Constitution, it is an overstep of their authority to do so. So if we think about this, the void ab initio clause as a restriction on the legislature's power, the legislature needs to understand and have some measure of knowing whether they are acting within the confines of that power. And the only way for them to be able to do that in an objective way is to look at the state of the law as it existed on the date a statute was enacted, which is exactly what this court in Jones, in Wilkins—
But again, the date that the statute is enacted will work for plenty of cases. But those cases that you're referencing in your brief are typically talking about statutes that have prior statutory enactments or prior constitutional enactments. They're not dealing with judicial precedent. And when you have judicial precedent that is applied retroactively, I do not think you can artificially separate them as you have tried to do here.
I think that you can't ignore judicial interpretations when looking at what the legislature is supposed to know. This court has presumed in other contexts, to be sure.
In your briefing, you talk about the idea that the legislature is presumed to act with knowledge of the law and that they have to make these decisions in that context. Well, what if, and again, not this record, I understand, but we have to decide where things go from here, right? What if you had legislators who were on record as saying, oh, it was my firm belief that Roe and Casey were on shaky ground and that whenever a case got to the Supreme Court, they were going to give a different outcome, And so, of course, I was aware of the law, but I also believed we needed a test case. I mean, I worry that the way you've constructed it, it's some sort of subjective understanding of a legislator as opposed to an objective test of what power a legislator had as a matter of law, not what they thought or felt. That seems really uncomfortable to me.
Certainly, and I'm not proposing a subjective legislator by legislator test or even subjective as the legislature as a whole. It's a presumption that this court has applied over and over again in that the legislature is presumed to know the law, and including judicial interpretations of that law. And this is, I'm sorry.
No, you go ahead.
This is not a case where there was gray area in this in 2019. This was a case where there were 50 years of Supreme Court precedent.
So, Counselor, let me ask you, do you have authority beyond Adams to help us get to where you're asking us to go with the void ab initio, particularly in light of the fact of what Justice Bethel said about the court saying that they have decided that Roe was always wrong, that it was never the law?
I do believe Adams is the best case, but it's certainly not the only one. In Grayson Robinson, this court looked to judicial interpretations to decide, it wasn't explicit that it was doing that, but to decide whether a law.
So in Adams, do you agree, Adams' year support statute, lots of different versions enacted, a couple enacted before the federal equal protection clause was enacted. There were also later year support statutes that one was totally reenacted and others amended. Do you agree that the earliest versions of that year support statute passed before the Equal Protection Amendment, but that were gendered statutes were void as soon as the Equal Protection Amendment clause was passed to the United States Constitution?
No, Your Honor, and I think it would be helpful to.
You do not think those were void?
No, Your Honor.
As of the adoption of the 14th Amendment?
No,
A
Your Honor.
statute
I believe they
discriminates
were
based on sex?
unconstitutional but not void, which is exactly what this court held in Adams.
I have more questions for Adams than our time would allow.
How does that get you to your point if you agree with that?
So they were not void because the 14th Amendment, until the decision of Orr versus Orr, and Reed, I guess, before that, 1971, the 14th Amendment Equal Protection Clause had never been interpreted to prohibit gender-based discrimination. It was never understood. There was no clearly established right.
Your argument is that you measured judicial interpretations at that time, right? I mean, that's what you gleaned from Adams?
Correct, Your Honor.
But I mean, the whole work that the void ab initio doctrine does is it tells you that the things that are void were void from the outset, whether there had been a judicial pronouncement or not.
I agree that there doesn't necessarily need to be a judicial pronouncement, but it's a question of whether there's a clearly established rule. I think is.
And that standard that you're saying, is that from that one little clause in Adams that says you look to the judicial interpretations of that time?
That's the best language, but that was the language that was when this court in Lawrence was describing the holding of Adams. That was the language that this court focused on. Same in James Beam. That was the language that this court focused on.
Those cases were overruled. It's also pretty clear that I think that in Adams, we actually did apply void ab initio and then took the, to me, somewhat suspect step of making an equitable exception to it. But we applied void ab initio.
I disagree that there was an equitable exception applied in Adams. There is certainly language within Adams that says, talks about a reliance interest.
Later cases, including from our court, interpreted Adams as such.
There are cases that use that language, certainly. I agree.
The challenge you have with Adams is that you like to cite Jones and Grayson, but Adams says this is not any of those cases. Like it expressly says, we are not governed by that kind of law. And then because part of the problem you have with Adams is that everything in it functionally ends up being dicta, right? Because in Adams, the act had been amended and Adams died after the amendment. I mean, in other words, all of the language that was problematic had been amended by the legislature after the fact, and that was deemed to be allowable, right?
That was, Your Honor.
And so when all of this discussion in Adams about void ab initio, it's not even really a void ab initio case at the end of the day, because they apply an act of the legislature that happened after all of it, after the 14th Amendment, and they say, we're going to apply that language because Adams died after the effective date.
Well, I think the reason that it is a void ab initio analysis is that an amendment cannot save an otherwise void statute. So that's what we saw, for example.
If that's true, then every single statute, including the 79 statute, was void.
Yeah, and
in
didn't they
Adams.
just, as a result of their ruling, didn't they find that at the time that the original statute was implemented, it wasn't unconstitutional? And so it wasn't void. I guess I'm trying to figure out where in the process do you think the ab initio comes in?
That's exactly right. They determined that it was not considered to be unconstitutional, despite it being passed in 1958, 60 years, nearly 100 years, actually, if I do my math right, somewhere in there, after the 14th Amendment. And because the 14th Amendment did not change between 1958 and 1982 when that case was decided. But they held that it was not unconstitutional when it was passed in 1958 because the 14th Amendment had not been understood as interpreted by the U.S. Supreme Court to prohibit gender-based
Are
discrimination.
you saying that when they were referring to that, they were talking about the 1958 statute, not the 1838 statute?
Yes, Your Honor, and this slide that I have up here, they talk about.
I think I agree with you. I mean, I think it makes the most sense that this is talking about, when they say original, the 58, because of that full reenactment.
Exactly.
But I don't think that changes that. I mean, if that's true, I think then that the sentence that flows from it, as the original year support statute, when adopted, was not violative of the Constitution under court interpretations of that period, is just a mere description. That's true. I mean, under the court interpretations of the period, the 1958 statute had not been declared unconstitutional, but that doesn't mean that it wasn't, because the Equal Protection Clause had been enacted and said you can't discriminate on the basis of sex.
It had been enacted, but it hadn't been understood, and it was not obvious from the face. We needed a judicial interpretation of the Equal Amendment.
That's the rub of this case, though, right? I mean, when Orr was decided, it was made clear to this court what had always been. Not before the.
But if it had always been, and I think that this is the state's argument and the point that you're making, Your Honor, is if it had always been, then that statute would have been held to be void because the 14th Amendment would have always prohibited those types of laws, but it was held not to be void. And
I admit, I also find that confusing. I don't think it all perfectly lines up.
Let's go back to the point you're making. You say that it's something that's void can't be saved by amendment. And I think it's important. I mean, we courts have a bad habit of putting in quotes, and we lawyers quote the quote without giving the context. When we talk about something not being able to be saved by amendment, it's usually in these cases where, city councilmen can't also be on the utility board. And then after the appointment, there's an amendment. That's clear. You can't go back. In other words, if I say to my child, you can't have 2 desserts in a day. That's the rule at our house. And the child has 2 desserts. And the next day I say, well, we're changing the rule. They still violated the rule on the day before, right?
sure.
Now, I can forgive that, right? As in my house, I would. But I can forgive that, but it still violated on the rule. So the later amendment can't save what was done that violated. That's the context in which we normally think about it. So in Orr, it's not that case. They're not doing an amendment to save something that happened before, Adams, talking about the Orr case. They're not trying to save the prior version or cases that were decided. They are trying to say, going forward, this is what we want the rule to be. It can't be understood to say that something that is determined to be unconstitutional can't be amended going forward. Then nothing would ever happen.
Well, what would happen is what this court has said to do in Jones and Wilkins and Grayson, which is for the legislature to go back and reenact the statute.
That's certainly an option. I mean, that's an option that's available. I don't think those cases say it's required under the circumstances like these, including because Adams says that Adams is not one of those cases, and you're relying on Adams.
I am relying on Adams, and I agree it's not exactly this precise fact scenario, and I wish I had a case that was this exact fact scenario to give to you all. It would be very helpful. But I think that the reasoning applies perfectly well. And this court has said that when the statute is void, it cannot be saved by an amendment unless the only way to reenact it is for the legislature to go back and repass it. And
That's the
Except then
Gower
we've got
line.
Sherman.
Yeah, that's the
Well,
Gower line, and then Sherman comes after.
Yes, except that Sherman was specifically about a constitutional amendment, which is on a different footing than a statutory amendment.
But it's, the question though is not, you're not saying the statutory amendment, you're saying that the statutory amendment's not allowed in light of federal constitutional law.
Correct.
But the federal constitutional law, I mean, by its own terms, I mean, even independent of the general rule that, decisional law is retroactive, I mean, Dobbs doesn't leave any doubt. It says it was, it was never the law. Whether you agree with that or not, they get to say that, right?
They absolutely do. But it doesn't change the fact, and the Supreme Court has also made clear that when it issues an opinion, it creates the binding rule that binds courts through the void ab initio clause, binds the legislature here until that rule is changed. And for 50 years, the rule was states could not ban abortions before the point of viability. And when the General Assembly passed HB 481 and sought to ban abortions 4 months before that point, that had been perfectly clear for 50 years, they directly conflicted with that precedent.
So how do we get beyond their statement, regardless of what side of the fence you come on, that it never was the law?
Answer that question.
Please.
It doesn't change the facts of the matter. We can get into an esoteric debate about what is the law and what is the meaning of the law and how do we get there. But the fact is that for 50 years, states were not allowed to enact these, that Roe and Casey were the law of the land, and that had this court case been brought in 2019, this court would have had no choice but to strike it down as void. And voidness is not something that can change over time.
Thank you,
Thank you.
Mr. Petrani, you have a little over a minute. Well over, 4 minutes.
Thank you, Your Honor.
But you can use 1 minute.
I will try to use as little time as possible, Your Honor. I just want to very briefly address this notion that we somehow didn't raise federal cases below. And our point has been the entire time that Dobbs is the controlling case here, that it's retroactive.
Can you please answer the question I asked your opposing counsel earlier about the notion that somehow the retroactive application of Dobbs does not affect the voidness analysis here?
Yeah, that was another one of my points, Your Honor. That doesn't make any sense. This was a point that I tried to make earlier. The entire theory of the case, from plaintiff's perspective, is that the Life Act was void in 2019 because of federal judicial decisions. That's their entire theory. And so the notion that somehow Dobbs does not undo that, it would be incoherent. And in fact, by the way, James Beam and Harper, especially Harper, already rejected this idea. In Harper, Virginia tried to defend its decision not to apply a decision retroactively by saying, well, this is really a state doctrine. It's a state way of understanding how to apply our state tax statutes retroactively and when not to, et cetera. And the Supreme Court said, absolutely not. Because underlying everything, at bottom, you're saying that our decision was not retroactive. You're saying that you are not bound by that decision in past years. And Harper already did away with that argument. I want to make just a couple of other points. I mean, first of all, on Adams, Justice Warren, I think Adams might have been a little bit confused about what exactly it was doing, and I think that that's part of the reason that there's no obvious answer as to what statute they were even talking about or anything like that. But I think it's very telling that counsel for plaintiffs just said that statutes enacted before the Equal Protection Clause are somehow not voided by the Equal Protection Clause until a judicial opinion maybe says so, and even at that point, it's not good enough because that judicial decision wasn't from the time. I mean, I wanted to come up here and kind of give you a demonstration of how sort of arbitrary this theory is. It seems like a kind of a good for one ticket only kind of theory, and I couldn't come up with a better example than that. I mean, under their own theory, that doesn't make any sense. And that's because, and this goes to another thing plaintiffs' counsel admitted, they have no cases. If this were true, if a court overruling a decision didn't actually wipe away the earlier decision, and statutes would still be invalid if enacted in that time period, you would have a case somewhere, sometime saying that. For 30 years, Lochner held sway. And Congress and states were passing statutes all the time that were violative of Lochner and its progeny. And nowhere in any of the judicial decisions to come out of that time is there even a whisper of the notion that simply because they violated judicial opinions that were later overruled, they somehow were themselves void. There is no authority for this theory anywhere. And I think that this court should avoid going down this road that would really exalt this court above its coordinate branches and say, our decisions bind you, as opposed to simply binding courts and parties before us. So for those reasons, we ask this court to reverse. Thank you.
Thank you, Mr. Petrani. Thank you, counsel, for fine arguments. We'll have you a decision as soon as possible. With that, we will be in recess until our next session tomorrow morning at 10 a.m.